हेलो फ्रेंड्स। मैं थोड़ा थोड़ा इंडियन पॉलिटी रीड करती रहती हूँ हर दिन, ताकि मुझे थोड़ा सा नॉलेज हो अपने कॉन्स्टिट्यूशन के बारे में। एक्चुअली एक सिटीज़न होने के नाते सबके पास थोड़ा बहुत नॉलेज होना चाहिए, और जो भी मैं रीड कर रही हूँ मैं सोचा मैं शेयर करूँ ताकि किसी और को भी थोड़ी बेनिफिट मिल सके। इस बुक के बारे में मुझे ज़्यादा कुछ बोलना नहीं है, काफ़ी फेमस बुक है और हर कोई रिकमेंड करता है पढ़ने को। और मुझे भी ये बुक काफ़ी सिंपल एंड ईजी लगा, एंड लैंग्वेज काफ़ी अंडरस्टैंडिंग होती है इसकी। मैं रैंडमली पिक करती हूँ एक टॉपिक पर डे और उसे रीड करती हूँ, एंड देन नोट्स बनाना एंड बहुत लॉन्ग प्रोसेस है। जो भी मैं रीड करती हूँ वो मार्क करती हूँ, जो इम्पॉर्टेंट की वर्ड्स होते हैं वो मैं मार्क करते जाती हूँ ताकि नोट्स बनाने में ईजी हो। ये आप भी गौर कर सकते हो। ज़्यादा मैं ये वीडियो लंबा नहीं बनाना चाहती, जस्ट आई वांट टू रीड इट, क्योंकि जो वर्किंग प्रोफेशनल्स होते हैं उनके पास ज़्यादा टाइम होता नहीं है। इस वीडियो को थोड़ा शॉर्ट रखना है ताकि हर कोई रिवीजन कर पाए इसे कम टाइम में। एंड बिलीव मी, ये टाइम वेस्टिंग वीडियो बिल्कुल नहीं है, इससे आपका थोड़ा बहुत रिवीजन हो जाएगा मेरे साथ साथ। So let's start this. The directive principle of state policy are enumerated in Part 4 of the Constitution from Article 36 to 51. The framers of the Constitution borrowed this idea from the Irish Constitution of 1937, which had copied it from the Spanish Constitution. Dr. B.R. Ambedkar described these principles as novel features of the Indian Constitution. The directive principles, along with the fundamental rights, contain the philosophy of the Constitution and is the soul of the Constitution. Granville Austin has described the directive principle and the fundamental rights as the conscience of the Constitution. Let's see the features. First one is the phrase DPSP denotes the ideals that the state should keep in mind while formulating policies and enacting laws. These are the constitutional instructions or recommendations to the state in legislative, executive, and administrative matters. According to Article 36, the term state in Part 4 has the same meaning as in the Part 3 dealing with fundamental rights. Therefore, it includes the legislative and executive organs of the central and state government, all local authorities, and all other public authorities in the country. The directive principles resembles the instrument of instructions enumerated in the Government of India Act 1935. In the words of Dr. B.R. Ambedkar, the directive principles are like the instrument of instructions which were issued to the Governor General and to governors of the colonies of India by the British government under the Government of India Act 1935. Know more about this. What is called directive principles is merely another name for the instrument of instructions. The only difference is that they are instructions to the legislature and the executives. Third one is the directive principle constitute a very comprehensive economic, social, and political program for a modern democratic state. They aim at realizing the high ideals of justice, liberty, equality, and fraternity as outlined in the preamble of the Constitution. They embody the concept of welfare state and not that of the police state, which existed during the colonial era. In brief, they seek to establish economic and social democracy in the country. The directive principles are non-justiciable in nature. That is, they are not legally enforceable by the courts for their violation. Therefore, the government, central, state, and local cannot be compelled to implement them. Nevertheless, that these principles are fundamental in the governments of the country, and it shall be duty of the state to apply this principle in making laws. The principle The directive principles, though non-justiciable in nature, have the courts in examining and determining the constitutional validity of law. The Supreme Court has ruled many of times that is determining the constitutionality and of any law. If a court finds that the law is questioned seeks to give effect to a directive principles, it may be considered law to be reasonable in relations to Article 14 or Article 19 and thus have such law for unconstitutionality. Now classification. The Constitution does not contain any classification of directive principles. However, on the basis of their content and direction, they can be classified into three categories with socialist, Gandhian, and liberal intellectuals. These are the keywords. You have to get more information about this by any of your source. You can use Google. Now we are having socialistic principles. These principles reflect the ideology of socialism. They lay down the framework of a democratic socialist state aimed to providing social and economic justice and set the path to a welfare state. They direct the state to promote the welfare of the people by securing a social order permeated by justice, social, economic, and political, and to minimize inequalities in income, state facilities, and opportunities. Just see Article 38. To secure, these are the points, to secure the right to adequate means of livelihood for all citizens, the equitable distribution of material sources of community for the common good, prevention of concentration of wealth and means of production, equal pay for equal work for men and women, preservation of health and strength for workers and children against forcible abuse, and opportunities for health development mental of children. Article 39. Just mark these points. To promote equal justice and to provide free legal aid to poor. Article 39A. Whatever I am marking, you can make notes. To secure the right to work, to education, and to public assistance in class of unemployment, old age, sickness, and disablement. 41. To make provision for just human condition of work and maternity relief. Article 42. To secure a living wage, a decent standard of life, and social and cultural opportunities for all workers. Article 43. To take steps to secure the participation of workers in the management of industries. 43A. To raise the level of nutrition and the standard of living of people to improve public health. To remember these points, you have to revise again and again. Now, Gandhian principles. Earlier we have seen that there are three, not in this page, here. Three broad categories with socialistic, Gandhian, and liberal intellectuals. Socialistic, we have read. Now we are having Gandhian principles. Okay. These principles are based on Gandhian ideology. They represent the program of the reconstruction initiated by Gandhi during the national movement. In order to fulfill the dreams of Gandhi, some of his ideas were included as directive principles. They require the state to organize village panchayats and endow them with necessary powers and authority to enable them to function as units of self-government. To promote cottage industries or an individual or cooperative basis in rural areas. To promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative societies. Article 43B. To promote the educational and economic interest of SC/STs and other weaker sections of the society and to protect them from social injustice and exploitation. Article 46. To prohibit the consumption of intoxication drinks, drugs which are injurious to health. Article 47. To prohibit the slaughter of cows, cows, calves, and other milch draft cattle and improve their breeds. Article 48. Now let's move to liberal intellectual principles. The principles included in this category represent the ideology of liberalism. The third one. They direct the state to secure for all citizens a uniform civil code throughout the country. Uniform civil code, you know about this. Article 44. To provide early childhood care and education for all children until they complete the age of 6 years. Article 45. To organize agriculture and animal husbandry on modern and scientific lines. Article 48. To protect and improve the environment and to safeguard forest and wildlife. Article 48A. To protect monuments, places and objects of artistic or historic interest which are declared to be of national importance. Article 49. To separate the judiciary from executive in the public service and state. Article 50. To promote international peace and security and maintain just, honorable relations between nations. To foster respect for international law and treaty obligations and to encourage the settlement of international disputes by arbitration. Article 51. Now, new directive principles. As we know that 42nd Amendment Act 1976 added 4 new directive principles to the original list, which are as follows. They require the state to secure opportunities for health development of children. Article 39. To promote equal justice and to provide free legal aid to the poor. Article 39A. To take a step to secure the participation of workers in management of industries. Article 43A. To protect and improve the environment and to safeguard forest and wildlife. Article 48A. The 44th Amendment Act 1978 added one more directive principles which requires the state to minimize inequalities in income, status, facilities and opportunities. Article 38. The 86th Amendment Act 2002 changed the subject matter of Article 45 and made elementary education a fundamental rights under Article 21A. The Amendment Directive requires the state to provide early childhood care and education for all children until they complete the age of 6 years. 97th Amendment Act 2011 added a new directive principle relating to cooperative societies. It requires the state to promote voluntary formation and autonomous functioning, democratic control and professional management of cooperative societies. Article 43B. Every line is important. Sanction behind directive principles. Now underline this. Sir B.N. Rao, the constitutional advisor to the Constituent Assembly, recommended that the right of an individual should be divided into 2 categories, justiciable and non-justiciable, which are accepted by the drafting committee. Consequently, the fundamental rights which are justiciable in nature are incorporated in Part 3 and the directive principles which are non-justiciable in nature are incorporated in Part 4. Justiciable is incorporated in Part 3 and non-justiciable is incorporated in Part 4 of the Constitution. Just remember this. Though the directive principles are non-justiciable, the Constitution Article 37 makes it clear that these principles are fundamental in the governance of the country and it shall be duty of the state to apply these principles in making laws. Thus, they impose a moral obligation on the state authority for their application, but the real force behind them is political, that is, of public opinion. As observed by Aladi Krishnaswamy Iyer, no ministry responsible to people can afford light-heartedly to ignore the provisions in Part 4 of the Constitution. Similarly, Dr. B.R. Ambedkar said in the Constituent Assembly that a government which rests on popular vote can hardly ignore the directive principles while shaping its policy. If any government ignores them, it will certainly have to answer for that before the electorate at the election time. The framers of the Constitution made the directive principles non-justiciable and legally non-enforceable because of these 3 reasons. Let's read. The country did not possess sufficient financial resources to implement them. The presence of vast diversity and backwardness in the countries would stand in the way of their implementation. The newly born independent Indian state, with its many preoccupations, might be crushed under the burden unless it was free to decide the order, the time, the place, and the mode of fulfilling them. The constitutional makers, therefore, taking a pragmatic view, refrained from giving teeth to these principles. They believed more in public opinion rather than in court procedures as the ultimate sanction for the fulfillment of these principles. Now, criticism तो होते ही है भैया हर फील्ड में, तो चलो इसको भी देख लिया जाए. The directive principles of state policy have been criticized by some members of the Constituent Assembly as well as other constitutional political experts of the following grounds. No legal force, illogically arranged, conservative, constitutional conflict. These are the 4 points. Let's study one by one. The directives have been criticized mainly because of their non-justiciable character, while TK Shah dubbed them as pious superfluous, and compared them with a check on a bank payable only when the resources of the bank permit. Nazir Uddin contended these principles are no better than the New Year's resolutions, well said, which are broken on the 2nd of the January. Even as T.T. Krishnamachari described the directive as a veritable dustbin of sentiments, and K.C. Ware are called them as manifesto of aim and inspirations, and opined that they serve as mere moral homily, and Sir Evo Jennings thought they are only a pious inspirations. Okay. Now, illogically arranged. Critics opine that the directives are not arranged in a logical manner based on a consistent philosophy. According to Ann's version, the directive principles are neither properly classified nor logically arranged. The declaration mixes up relatively unimportant issues with the most vital economic and social questions. It combines the rather incongruously the modern with the old previous provisions suggested by the reason and science with provisions based on purely on the sentiments and prejudice. Sir Evo Jennings too pointed out that these principles have no consistent philosophy. Now, conservative. According to Sir Evo Jennings, the directives are based on the political philosophy of the 19th century England. He remarked, the ghost of Sydney wave and Beatrix wave stalked through the pages of the text. Part 4 of the Constitution expressed Fabian socialism without the socialism. He opined that directives are deemed to be suitable in India in the middle of the 20th century. The questions whether they are suitable for the 21st century cannot be answered, but it is quite probable that they will be entirely outmoded. Constitutional conflict. K. Santhanam has pointed out that the directives relate to a constitutional conflict between the center and the state, between the president and the prime minister, and between the governor and the chief minister. According to him, the center can give direction to the state with regard to the implementation of these principles, and in case of the non-compliance, can dismiss the state government. Similarly, when the prime minister gets a bill which violates the directive principles passed by the parliament, the president may reject the bill on the ground that these principles are fundamentally to the governance of the country, and hence the ministry has no right to ignore them. The same constitutional conflict may occur between the governor and the chief minister at central level. Utility of directive principles. In spite of the above criticism, shortcoming, directive principles are not an unnecessary appendage to the Constitution. The Constitution itself declares that they are fundamental to the government of the country. According to L. M. Singhvi, an eminent jurist and diplomat, the directives are the life-giving provisions of the Constitution. They constitute the stuff of the Constitution and its philosophy of social justice. Ansi Chagla, former Chief Justice of India, is of the opinion that if all these principles are fully carried out, our country would indeed be a heaven on earth. India would then be not only democracy in the political sense, but also a welfare state looking after the welfare of its citizens. Dr. Ambedkar had pointed out that the directives have great value because they lay down the goal of Indian polity is economic democracy, as distinguished from the political democracy. Greville Austin opined that the directive principles are aimed at furthering the goals of the social revolution, or to foster the revolution by stabilizing the conditions necessary for its achievement. Sir B. N. Rao, the constitutional advisor to the Constituent Assembly, stated that the directive principles are intended as moral precepts of the authority of the state. They are at least an educative value. According to N.C. Stilwell, the former Attorney General of India, directive principles, although confer no legal rights and create no legal remedies, the insignificant and useful in the following ways. They are like an instrument of instructions or general recommendations addressed to all the authorities in the Indian Union. They remind them of the basic principle of new social and economic order which the Constitution aims at building. They have served as useful beacon lights to the courts. They have helped the courts in exercising their power of judicial review, that is, the power of determining the constitutional validity of the law. They form the dominating background of all the state action, legislative and constitution or constitutive, and also a guide to the courts in some respects. They amplify the preamble which solemnly resolves to secure all citizens of Indian justice, liberty, equity, and fraternity. The directives also play an important role. They facilitate stability and continuity in the domestic and foreign policy, in political, economic, and social spheres, in spite of changes in the party in power. They are supplementary to the fundamental rights of the citizens. They are intended to fill in the vacuum in Part 3 by providing for social and economic rights. Their implementation creates a favorable atmosphere for the full and proper enjoyment of the fundamental rights by the citizens. Political democracy without economic democracy has no meaning. They enable the opposition to exercise influence and control over the operations of the government. The oppositions can blame the ruling party on the ground that its activities are opposed to the directives. They serve as crucial test for the performance of the government. The people can examine the policies and programs of the government in light of these constitutional declarations. They serve a common political manifesto. A ruling party, irrespective of its political ideology, has to recognize the fact that these principles are intended to be its guides, philosophy, and trends in its legislative and executive acts. Conflict between fundamental rights and directive principle. The justiciability of fundamental rights and non-justiciability of directive principles on one hand, and the moral Obligations of state of implement directive principles. Article 37, on the other hand, have led to a conflict between two since the commencement of the Constitution. In the Champakam Dorairazan case, 1951, the Supreme Court ruled that in case of any conflict between fundamental rights and the directive principles, the former would prevail. It declared that the directive principles have to conform to and run as subsidiary of the fundamental rights, but it also held that fundamental rights could be amended by the Constitution by enacting Constitutional Amendment Act. As a result, the Parliament made the First Amendment Act 1951, the Fourth Amendment Act 1955, and the Seventh Amendment Act 1964 to implement some of the directives. The above situation underwent a major change in 1967 following the Supreme Court's judgments in the Golak Nath case 1967. This case is very famous. You must know more about these cases. In that case, the Supreme Court ruled that the Parliament cannot take away or abridge any of the fundamental rights which are sacrosanct in nature. In other words, the court held the fundamental rights cannot be amended for the implementation of the directive principles. The Parliament reacted to the Supreme Court judgment in Golaknath case 1967 by enacting 24th Amendment Act 1971 and 25th Amendment Act 1971. The 24th Amendment Act declared that the Parliament has the power to abridge or take away any fundamental rights by enacting Constitutional Amendment Acts. The 25th Amendment Act inserted a new article 31C, which contained the following two provisions: 1 and 2. No law which seeks to implement the socialistic directive principles specified in Article 39B and C shall be void on the ground of contravention of the fundamental rights conferred by the Article 14, Article 19, that is protection of 6 rights in respect of speech, assembly, movement, etc., or Article 31, right to property. No law containing declaration for giving effect to such policy shall be questioned in any court on the ground that it does not give effect to such policy. In case of Nanda Bharati case 1973, the Supreme Court declared the above second provision of the Article 31 unconstitutional and invalid on the ground that judicial review is the basic feature of the Constitution and hence cannot be taken away. However, the first provision of Article 31 was held to be constitutional and valid. Later, 42nd Amendment Act 1976 extended the scope of the above first provisions of Article 31C by including within our protection and law of the implement any of the directive principles and not merely those specified in Article 39B and C. In other words, the 42nd Amendment Act accorded the position of legal primacy and supremacy to the directive principles over the fundamental rights confirmed by the Article 40, 19 and 31. However, this extension was declared as unconstitutional and invalid by the Supreme Court in Minerva Mills case, in 1980. It means that the directive principles were once again made subordinate to the fundamental rights, but the fundamental rights conferred by Article 14 and Article 90 were accepted as subordinate to the directive principle specified in Article 39B and C. Further, Article 31, right to property, was abolished by the 44th Amendment Act 1978. In the Minerva Mills case 1980, the Supreme Court also held that the Indian Constitution is founded on the bedrock of the balance between fundamental rights and directive principles. They together constitute the core of the commitment of social revolution. They are like two wheels of a chariot, one no less than the other. That is a good example. To give absolute primacy to one over the other, is to disturb the harmony of the Constitution. This harmony and the balance between two is an essential feature of the basic structure of the Constitution. The goals set out by the directive principles have to be achieved without the abrogation of the means provided by the fundamental rights. Therefore, the present position of that the fundamental rights enjoy supremacy over the directive principles. Yet this does not mean that the directive principles cannot be implemented. The Parliament can amend the fundamental rights in implementing the directive principles so long as the amendment does not damage or destroy the basic structure of the Constitution. Now we are having implementation of directive principles. Since 1950, the successive government at the center and in the state have made several laws and formulated various programs for the implementing the directive principles. These are mentioned below. The Planning Commission was developed in 1950 to take up the development of the country in planned manner. The successive 5-year plan aimed at securing socio-economic justice and reducing inequalities of income, status, and opportunities. In 2015, the planning committee was replaced by a new body called Niti Aayog. Almost all the states have passed land reform law to bring changes in the agrarian society and to improve the condition of the rural masses. These measures include abolition of intermediaries like zamindars, jagirdars, inamdars, etc., tenancy reforms like security of tenure, fair rents, etc., imposition of ceilings on land holdings, distribution of surplus land among the landless laborers, and cooperative of the farming. The Minimum Wages Act 1948, the Payment of Wages Act 1936, the Payment of Bonus 1965, the Contract Labor Regulation Abolition Act 1917, the Child Labor Prohibition and Regulation Act 1986, the Bonded Labor System Abolishing Act 1976, the Trade Unions Act 1996, the Factories Act 1948, Mines Act 1952, Industry Disputes Act 1947, the Workmen's Compensation Act 1923, and so on have been enacted to protect the interests of the labor sections. In 2006, the government banned the child labor. In 2016, the Child Labor Prohibition and Regulation Act 1986 was renamed as Child and Adolescent Labor Prohibition and Regulation Act 1986. These are the important ones. You have to mark this and know more about this. The Maternity Benefit Act 1961 and the Equal Innovation Act 1976 have been made to protect the interests of the women workers. Various measures have been taken to utilize the financial resources of the promotion of the common good. These include the nationalization of life insurance 1956, the nationalization of 14 leading commercial banks 1969, nationalization of general insurance, abolition of private purchase 1971, and so on. The Legal Services Authority 1987, Khadi Village Industries Board, Khadi and Village Industries Commissions